Roll call, pledge of allegiance, and I have a couple of announcements to make. So, roll call.
Tom Tyler.
Here.
Lori Longy.
Here.
Donna Tubanowski.
Here.
Okay, if you don't mind, we're going to stand and do the pledge of allegiance. The flag is behind us on the left-hand side. Pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
God bless America. God help Enfield.
Thank you very much. I do have a couple of announcements. The first one is a fire announcement or any emergency that may take place. If we have two exits, so for those people that can come towards the front of the room, there's an exit over there. Go through the doors and then to the left, and you'll go down the stairway and out into the parking lot. If you're in the back, you have the exits in the back where you can exit that way and go out and again into the parking lot. I see where, I think, State Representative Dubinsky, come on up if you don't mind. Rachel's going to meet with you for a second. We're just getting started. Thank you. Okay, so that's it for the fire announcement. The other announcement I wanted to make is that the BAA was denied permission to transmit our meeting tonight live on the town television. So if you'd like to comment on that, about not having this meeting televised, then I suggest you contact your town council members, the mayor, manager, or whoever. I did request it, and I was told that it was not an official town meeting, which the BAA is an official agency. We file all of our paperwork, and this is an official organizational special meeting for the BAA. Anyway, in terms of our next item on the agenda, we're going to skip over our discuss or approve minutes and move on because we have two speakers here tonight that we're very honored to have them with us. And also we're going to get into just quickly the BAA organizational preparations for the hearings. We have motor vehicle hearings coming up on September the 6th from 4 to 6 in the Enfield room, that's right down below us. And then on the 12th from 5 to 7, again, the Enfield room down below us. And then on a Saturday, the 16th, from 10 in the morning till noontime. And hopefully that'll be it. If you have an appeal, come on in and see us. We will have forms if you didn't find anything online. And at this stage, we're going to have Donna and Lori go through the forms that you may need for the automobile appeals.
Okay, so online is the appeal form. There's copies over there. It looks like this, and there is an authorization. If you can't go for your hearing during those times that Tom said, you can appoint somebody to do so. Do that on the back of the form. We also have a first come, first serve on all of the cars. So please come with the vehicle. We also you have to bring some backup. So you need to look at the NADA or the Kelly Blue Book and come with any of it that will prove your case as to why you think your assessment is too high. Antique cars, which is a vehicle that's over 20 years of age. You have a one-page form from motor vehicle to complete, and that gets you the antique plates. The town does have a mechanics form for the town of Enfield. It's 2 pages. It requires a mechanics license. Mechanics don't have license in the town, the state of Connecticut, so leave that blank. He did make the form a little harder, so you have to have it done by the mechanic, and you also have to have it notarized. So the form that is out for right now for any of this form here, which is, he has a deadline of December 31st. Now this is for the period of the next taxes. So this form, if you were to complete it right now online, that is for the period of starting the tax period of January 1st, 2024. It has to be completed by December 31st, 2023. If you do have a bill that you paid in July and you want to come in to appeal your tax bill in September, you've paid that bill, so you will be reimbursed by the town. Other than that, you get reimbursed, and remember that if you have a supplemental bill, that's if you had a vehicle you registered anywhere between July and October, there could be a supplemental bill which you can also appeal. So the forms are online. If you have any questions, you can always contact us. Thank you.
Thank you, Donna. Okay, now we're going to, I want to make one other announcement, which is I want to report on the status of our request for a special meeting with the town council. And I have had ongoing discussions between myself and Mayor Cusati to come up with a mutually convenient date in mid-September for the BAA to make its presentation in town council chambers live on town TV, uninterrupted, unrestricted time limit, with questions and answers from the councilors as had been promised to us a couple of months ago. I would like to thank Councilor Hopkins for making the motion to have us get this opportunity, and Marie Pilsner, who seconded it, and then of course Doug Finger, Mike Ludwig, Ken Nelson, and Lori Ungeheuer for supporting the BAA efforts to respond to that report and for the taxpayers to learn what is going on and what we have to share. So I'd like to thank them for that. And with no further ado, then I'm going to ask Attorney Rachel Baird to come, and she's going to discuss some legal and practical topics related to the assessment issues that affect the rights and responsibilities of taxpayers in the town of Enfield. And she's a noted civil rights attorney, and she also serves as a BAA lawyer. So, Rachel?
Thank you, Tom. Thank you, Donna. I have been representing the BAA since last year. I've attended some town council meetings as well as a workshop in
You gotta be
June.
higher to your face. For
Okay, is this better?
Yes.
Everybody can hear me now?
Yeah.
Okay, so my name is Rachel Baird. I've been representing the BAA for about a year now. And I've been asked tonight to address 4 issues that have popped up in the report, and there's been some attention given to them, and they are somewhat legal issues, if not entirely legal issues in certain aspects. And so I'm going to focus just briefly tonight on trespass, and by trespass I mean what right or under what circumstances can an assessor come onto private property to assess property. Eavesdropping, that's something that came up in the report. It was somewhat diminished by the author of the report as a red herring, where he alleged that it was exaggerated by the Board of Assessment Appeals. So I'd like to address exactly how eavesdropping came up. Alteration of documents, there have been some allegations that the BAA documents were altered in some aspects after they left the BAA. I'd like to address that. And finally, in the report, there's discussion of zero value and whether it is in fact illegal, as the report indicates, to value a property at zero. So let's begin with trespass. In the report, the attorney who wrote the report, Attorney Coppola, references a case, Basilicas versus Town of Bloomfield. And he indicates in that case that the judge said that it's not a Fourth Amendment violation for a tax assessor to come onto your property. Now, to come into your house, yes, but not to come onto your property. But in fact, what that case actually says is that Basilicas went to the Board of Assessment Appeals in his town of Bloomfield, and he challenged the Board of Assessment Appeals and their valuation. And what the town says was, well, you didn't let us on your property, so how are we supposed to assess it? But under Practice Book Rule 13-9, which are the rules how lawyers proceed in civil matters, the town said, we want to inspect the property so we can in fact make our case. And the judge said, okay, I'm going to make an order that the town can go on that property and inspect it. So the report that was prepared for the town left all that out and just cites the judge as saying this would not be a Fourth Amendment violation. Well, there was a judge's order that the town in fact could go on the property. So that was left out of the report. So when you read the report or when you hear about the report, please know that attorneys disagree all the time about things. That's why there's usually two sides in each case. And judges disagree about things all the time. So just because an attorney wrote the report and made some conclusions in that report doesn't mean everybody would agree with that, and doesn't mean that all courts would agree with it. Now, Ms. Longy, a member of the Board of Assessment Appeals, and Ms. Dubanowski, I believe they're the ones that noticed during some hearings last year that a tape recorder had been left in the hearing room, and it was on top of a coat rack, and they noticed that it was there. And they learned that it in fact belonged to the tax assessor and was put there by the tax assessor. And in the interviews that they gave with regard to the report, they told Attorney Coppola about this, and in his words, it was greatly exaggerated what actually happened. He actually said, based upon the totality of the evidence, we find these accusations to be exaggerated at best. Well, eavesdropping is defined as mechanical overhearing. And mechanical overhearing is when you put a device in a room and you leave the room and the people in the room can't see the device and don't know they're being recorded, and they talk freely. And we're not talking about a BAA meeting, we're talking about breaks where people are in the hallway or making phone calls to people, and these recorders are there recording and people didn't know about it. And that's what Ms. Longy noticed, and that's what Ms. Dubanowski noticed. And it was somewhat disregarded and diminished in the report, but the BAA viewed that as an invasion of not only its privacy, but an invasion of the privacy of any citizens or residents who happen to be in the area. Now, altered documents, there were some mentions in the report about the BAA not complying with the Freedom of Information Act, not turning over their documents willingly. Well, there are a couple reasons for that. The BAA did not want their documents changed or altered in any way and wanted to keep them in the condition that they put them in after the hearings were over, because they could be used in court. And if documents are going to be used in court, you want the decisions you made to be written down and not changed. And in fact, there were grids, land grids, in certain appeals that when they were turned over to the tax assessor's office, there were notations made on them without a name put to it, without a date, and then they were sent back to the BAA, and it made it look like the BAA had made these notations on those documents when in fact they had not. So the BAA has been somewhat hesitant to hand over its documents. And in fact, its documents have been changed, and there's no indication on there of who did it, so it makes it look like the BAA did it. Finally, in the report, there's some talk about zero valuation of property. And in fact, it's mentioned as being illegal, being an illegal act to zero value a property. But in the report, there's a case that's mentioned, Breezy Knoll Association versus Town of Morris, which indicates that if a property is not marketable, that it can in fact have zero value. And that case cites another case that says encumbrances can reduce property's value to zero And that's cited in a very case that is in a report prepared for the town that says you can't value property at zero. So I'm just giving these 4 examples to let everyone know on behalf of the BAA that just because there was a report written by an attorney, it doesn't have to be accepted at face value. Questions need to be asked about the report, and questions need to be asked why, in fact, the person writing the report sat almost like an appellate court over the BA and judged their decisions. We have a process whereby taxpayers have their property assessed, and their first line of appeal, the most effective, inexpensive, and expedient line of appeal, is to the Board of Assessment Appeals. There's no fee, a lot of people don't hire lawyers, and it's comfortable, and you go in there and you make your case. And if you still don't like that case, then you can go to Superior Court, where it gets a little more complex. And for the BAA, from their position, to have a report that basically is sitting in judgment of their decisions, when it's their jurisdiction and their province to make these decisions, and if anybody doesn't like it, they go to the Superior Court, and by anybody I mean taxpayers. That is one of the issues that the BAA wanted me to point out tonight, and wanted to make sure everyone recognized that just because there is a report, and just because money was spent on that report by the town, doesn't mean that we have to accept the report at face value. And please, please continue to ask questions about what is in the report. Thank you.
Thank you, Rachel. Okay, now we're going to ask a farmer, a lawyer, and a state representative from the 47th District. Carol Hall was instrumental in getting him to come here. Doug Dubitsky, who is very familiar to a lot of the farming community, so we thank him for coming. Doug?
Thank you. Appreciate it. Can everybody hear me? Yes. Okay.
Hit the button.
Hit the button. Button says on. You're good.
Hold it closer.
Am I good?
Yep.
Everybody can hear me?
It's not on. Mic's not on.
No? Can't hear me. Try it again.
Hold it closer to your mouth. Yeah, it's not.
No, it's not there.
Any
not on.
closer, it'd be behind my head.
Yeah, it's not. It's not on.
I can speak very loudly. Is that better?
Excellent.
All right. The last time I spoke to a crowd in Enfield, I believe it was a similar situation. It was at one of the schools. I'm sorry, I can't remember what school. I was asked by gentleman from the Department of Agriculture to come and talk to him and Joan Nichols from the Farm Bureau about an assessment issue. So I showed up thinking that we were going to come and sit in a conference room and talk. And we walk into this big auditorium with 100 or so people in it, and I say, wow, it's a big group, who's speaking? And he said, you are. So, thankfully this time I knew that I was coming here, and I knew there would be some people interested to hear what I had to say, hopefully. My understanding is that you've still got the same problem, in that you've got an assessor who has removed certain properties from PA 490, and I am here to explain to you what the situations are under which that is allowable. I don't know anybody's individual situation. What I'm saying is not legal advice. I'm an attorney, but I'm not your attorney. So what I'm saying isn't legal advice. It's just one guy talking to a bunch of people about the law. Once your property is in PA 490, there are only two ways that it can be removed. Two situations under which an assessor is legally allowed to take you out of PA 490. It's right here in Connecticut General Statutes 12-504H. That's the statute. And it's if you change the use, that it is no longer being used as a farm, or you sell it. That's it. The assessor cannot come and say, well, I made a mistake when I originally put it into PA 490, therefore I'm changing it. Even if the assessor can prove that they made a mistake, it doesn't matter. Once it's in PA 490, there are only two ways it can come out. If you stop farming or you sell it. That's it. My understanding is the assessor is going back and reassessing things, checking to see if the farming was correctly assessed in the first place, taking certain pieces out, saying that scrubland or ledge or forestry or forest land is not part of the farm unit. If I were in your situation and my assessor did that to me, I would tell him that's too damn bad. Connecticut General Statutes 12-504H says specifically, and I'll read it to you. Any such land which has been classified by a record owner shall remain so classified without the filing of any new application subsequent to such classification, notwithstanding the provisions of section 12-107C, 12-107D, or 12-107E, and 12-107G, until either of the following shall occur. 1, the use of such land is changed to a use other than that described in the application for the existing classification by said record owner, or 2, such land is sold or transferred by such record owner. Period. That's it. So, if my understanding is correct, that is still a problem here, then there are options. There are two statutes under which a landowner whose land is wrongly taken out of PA 490, two statutes that provide appeals procedures. One is Connecticut General Statutes 12-107C. That is the classification of land as farmland, and that explains when and how a assessor can classify a piece of property and what a landowner can do if they are aggrieved. If you are denied farmland status, or if you are taken out of farmland status and you believe that decision was wrong, you are considered aggrieved. And there are things you can do. You can appeal to the Assessment Board of Appeals, which is supposed to act as a appeals decider, appeals court, as you will, that is taking evidence from two parties, from you, the landowner, and from the assessor and making an independent judgment of which one is right, or if they're both wrong or both right, they have the option to make a decision. You can bypass them and go directly to court, or you can go to the Board of Assessment Appeals, see what they say, and if you don't like it, then you can appeal to the court. You can appeal under two different statutes. One is 12-117A, the other one is 12-119. There are different timelines, different deadlines, different statutes of limitation for each of those two. 12-117A is for an excessive assessment. So if I think my farm is worth $100,000 and the assessor assesses it for $200,000, I think that's excessive. So I can appeal that. The other one, 12-119, is for a wrongful assessment. So if I say my property is a farm and the assessor says, no it isn't, that's a wrongful assessment. It's not necessarily excessive, it's wrongful. Two very different statutes. Under 12-117A, you have 2 months from the date that the Board of Assessment Appeals makes a decision to go to court. If you miss that deadline, you are what's called in the legal profession SOL. If you miss that deadline, there is no going back. That's it. You've missed the statute of limitations, you missed by 1 day, you're done. 12-119, it's 1 year from the date of the assessment. So if you're denied farmland status, or if you get a notice that your farmland status has been revoked, you have 1 year to appeal that to the court. 117A, if you win, the court can tell the town to repay any excess tax you paid. With 119, you can also get costs and attorney's fees. So I have done many of these, both cases, 117A and 119, and typically farmland classification cases are brought under 12-119 because it's a wrongful assessment, not necessarily excessive. Frankly, most people who get farmland classification don't really care what the number is, because since it's a use statute, they could assess your property for $50 million as long as you're only being taxed on the farmland use of it, which is generally a few $100s per acre. Most people don't care what the actual assessment is, what the actual valuation is, so long as the assessment after the farmland deduction is reduced. I probably don't have any more time, but I did not bring any cards with me, but my email address is very easy to remember. It's doug@lawyer.com. So if you want to get in touch with me, if you have specific questions about your specific problem, feel free to get in touch.
Thank you very much. Okay, How's this? Is this better? Okay. Anyways, the next part of our program tonight in our meeting is one that the BAA has been anxiously looking forward to for quite a time. And so what you're going to learn tonight is what is it that they, whoever they is, have been trying so hard to prevent the BAA from saying and for the taxpayers from hearing and learning. So this evening, we're finally going to be able to open our mouths and let you know a lot about what's going on and or has gone on. It's not everything, but you're going to learn a lot. So the first poster that I have is it's a copy of an email from Todd Helms to the town manager, and it's dated June 16th of 2022, so it's a little over 14 months ago. And this particular email you'll see in the lower right-hand corner, there's a number on it, says Enfield 0051. That's our page 1 of our handout. When we're done tonight, we're going to give handouts. We hope we have enough for everybody, but every poster you see and every a lot of the documents are going to be in this handout. So the handout is extensive. It's 88 pages, but we think a lot of it you may not be interested in, but a lot of it different people will be, and we want you to know the whole story and then you can do what you will with it. But anyway, so now to get to this particular email, it's sent to the town manager from Todd Helms. He also copied the town attorney and the finance director. And what this stemmed from is the BAA last year had found what's called effective year built. This is the one where Donna was up last month talking about her house, and her house seemed to get younger as it got older based upon some formula or calculation that Vision and Todd Helms was doing. We called it the Fountain of Youth. So after we had written our report last year, and we had cards that showed the effective year built, it showed an audit trail, it had a lot of information on the street cards, then we found out that a month or so later, that information had been suppressed, it was gone. Fortunately, we had a copy of what we had printed out, but the official town position was that we were not telling you guys the truth, and that there was no such thing as this fountain of youth and suppression of evidence. So this particular email, the reason I thought it's very important is the very first line where I have a red arrow and I've underlined it. It says, I did suppress the EYB, effective year built, on the cards after the PRCs, those are the personal residential or property residential cards, were printed for the BAA. Again, I did suppress the EYB, effective year built, on the cards after the PRCs were printed for the BAA. So that's an admission that in fact, now we know why it went poof, and it was just disappeared because he hit the button to suppress it. So then he goes on though to say that it's confusing to people because the BAA was obvious that we had no concept of effective year built, and they're supposed to be well versed. And then he says, I felt it prudent to suppress the field as it has no effect on value. Lori's going to get up in a minute and show you where it does have an effect on value, and it's generally accepted, well not generally, it is accepted on the appraisal standards. And the reason Lori's going to do that is she's the only one throughout this whole process who's certified as an appraiser in Connecticut, residential and commercial. Nobody from Vision is, and the assessor's not. So when he said that it has no effect on value, she's going to show you where it does. And then the other part he ends up saying is that it tends to lead to confusion for both the uninformed and for the laypersons. So apparently we're too dumb, and Enfield people are pretty dumb, so he doesn't want to confuse you more by telling you the truth and what they've done. So with no further ado, I'm going to ask Lori to go through her. Okay, thank you.
At the last meeting, I did go over the cost approach, which I explained that the replacement and reproduction costs minus depreciation plus site equals the value of your property. Part of the formula is depreciation. Depreciation can be physical, functional, or external. An external example could be that you live near a dump, a zone change, or a highway, something beyond the property. Depreciation can be curable or non-curable. A structure's effective age reflects the quality of construction, the degree of maintenance it's received, and remodeling. The effective age divided by the total economic life equals depreciation. And depreciation is loss in property value from any cause. Effective age is an important component of the formula to arrive at depreciation. Depreciation does affect property values, and this is actually sourced out of the Fundamentals of Real Estate Appraisal, the 8th edition. And according to our assessor, it has no value. I'm going to discuss, now?
Tap the top, just tap.
Okay. Top?
Tap it.
It's very temperamental.
Testing.
Okay.
It only likes
Test
one.
time.
I talk with my hand, so I'm gonna hold it lower this time. So I also would like to mention that there were 3 transcripts in the report that was done by, we call it the Coppola report. The town managers who talked about a taxpayer who was a problem, and also she mentioned was extremely arrogant and entitled. And then a transcript was not done from June Perry, which was Vision Appraisals, and James William, he was also from Vision Appraisals. And I'm sure after I read this card, you may know why that they were not transcribed. Card number 3, we had to listen to the audio of the interviews of all 3 of those people, write down what they had said, and each of them were a couple hours long. So on the interview with June Perry, she was the Vision District Manager, and it was at 1.07.13 on the tape, if anybody wants to review it at some point. Mario Coppola, does the effective year bill affect the valuation of a property? June Perry, yes. Mario Coppola, why? June Perry, because it's depreciation. So again, once we create that table, it goes to average good, very good, excellent, and rebuild. Then vice versa, fair, poor, very poor. There are 3 types of depreciation: physical, functional, economic. That is the one way we change the depreciation, and it's through the year bill and the effective year bill. So when we put a condition on a property that is average or good, that is creating the EYB. Interview with James William, Vision Project Manager. 1052, marked on the tape. Mario Coppola, do you generally use the income approach as the primary way to determine fair market value? James Williams, no. The cost approach is normally the primary method we use. Mario Coppola, why is that? James Williams, it's more consistent for at least mass appraisal purposes than using the income. It's more of an assessor preference on how they want things done in the future. Most assessors want us to do it on the cost so they can manipulate the value in the interim years. Manipulate the value. It's totally wrong to do this. The assessors are in charge of Vision,
So James Williams reveals that the assessors want the cost approach so they can manipulate the value with the depreciation. Simple as that. Mario Capola ignores this information in the report, and I'm sure that's why there were no written transcripts of these three people.
Thank you, Lori. Again, the important parts of that are that the email says that it has no effect on value. That's completely debunked. And when the vision person says that the reason they use the cost method is because it allows assessors to manipulate the numbers, that causes a chill to go through our bodies. The other thing that I just feel compelled to comment on is when the town manager in a video makes remarks about a taxpayer that the person's extremely arrogant and entitled, I'm wondering what relevance does that have to how that taxpayer is treated in the administration? And also, what relevance does it have to the value of property for tax purposes? I just saw no reason for that at all. But I did agree with the town manager's last part of her statement that the taxpayer is entitled, in that he's entitled to be treated fairly and honestly by his administration and the government. He's entitled to be treated, as are all of us, with dignity and respect. And we're entitled to a fair, just, equitable tax treatment, as are all taxpayers, whether she likes us or not. Anyway, that being said, I'm going to go to the next poster, please. Thank you, Donna. Okay, this next one is page 2 on our handout. It's going to be, the only reason I'm saying these pages is there's going to be a YouTube video of it, so if you want to re-watch it sometime with the documents in front of you, then you can follow. So I'm going to, from time to time, be talking about page numbers. It's also got an Enfield 2946 number in the lower right-hand corner. And what this was is a letter that I did on behalf of the Board of Appeals dated March 21st to Todd, asking him for some additional information because it had, at that point, reversed 44 of our decisions from the preceding year. Later on, he reversed another 4, so it's a total of 48. But anyway, with this, I asked him in the first line of the second paragraph, since each of your revision letters included only a brief conclusory statement of your opinion, I wanted to know if you consulted with and or relied upon any experts, such as attorneys, accountants, appraisers, or soil scientists, or if you relied on any other documents that might be helpful. I then pointed out several properties that they had, they being, oh, I don't know who they is other than Todd at the time, had problems with. He commented on 78 Park Avenue, that's Longy, 54 Virginia Avenue, Romano, solar properties, including a tax stabilization agreement and solar carports, that was Jarmonk and Antonacci, and then any other properties. And I told him this would be very important to us because we wanted to understand and give everybody a fair hearing, including the town. So if he could give us some more information, or at least confirm that he have any expert opinions upon which he relied on, it would be critical to us in evaluating the evidence and doing what we thought was fair, right, just, and equitable. So following that, I did learn that other than the town attorney, who didn't give him a written legal opinion on anything he cared to share with us, he did consult with the town attorney, but nothing that he could share with us. There were no other attorneys, no accountants, no appraisers, and no soil scientists that he consulted with in making his decisions. So, that being said, then we proceeded with our hearings, and we gave everybody a fair hearing and rendered our decisions. Hold on one second, please. Okay, thank you. Okay, number, yeah.
Come on, Vanna.
Okay.
This one?
Oh, yeah.
Vanna, yeah.
No, wait a minute. 'Cause we don't want to mess these up, right? This one or this one? Neither. That's what I thought you were going to say. That's what I thought. Okay, just making sure and then I hide.
Backwards.
You got it.
That's good, okay, thanks.
Dan is screwing up already.
Okay, so you're probably wondering,
No.
can we hear? No. You're probably wondering, well, you're definitely wondering now. So anyway, you're probably wondering, how is it that we got these documents? And so I want to show you how we got them, because they're town documents, you know, so it's documents, they wrote it, not us. I didn't write it for them and say, hey, sign this, but, so what's happened is, the firm that was doing the investigation actually was cooperative with us. When we gave our interviews, we said we wanted a copy of anything that they were having, and we like it in electronic form. In order for us to cooperate with it, we want the same access that they have and the town has. So that being, they were cooperative with us. So what happened is, though, we were trying to get access to 4,000 documents that the town had filed with the town clerk's office, that they had told the town council and the public that if you want to see them, you have to go to the town clerk's office, open 9 to 5, or you can send them 50 cents for each page. There were a total of 10,000 documents. So what happened is, Rachel, our lawyer on our behalf, sent an email to the town clerk, and basically she tells the town clerk that we're aware that they have electronic transmission of these documents, and can you please tell us how we can get it from you? And so she sent that request on July 18th at about 11:09 in the morning, and then she sent a copy to the town attorney, Talberg, and then the next day the town clerk response was basically there's no electronic access on that date as of 3:45 in the afternoon that she's aware of, but we can inspect. And then she says 50 cents a page, so you have to pay in advance. So if you want, send them $5,000 and they'll copy everything. So what she did say was that my office, is in possession of the paper copies, but my office does not have possession of any electronic files nor access to them, other than the final report. So she gives us a site for where you go to get the final report in the appendix. But all the rest of the documents, she says, and it's carefully worded because she doesn't say it doesn't exist. She just says she doesn't have possession of it, she doesn't have access to it. So what had happened is, at the same time Rachel sent that, I was trying to get it from a parallel source, which is Berkham Moses. And so then what happened is, after Rachel had sent, I sent mine at the same time Rachel sent hers. So she sent hers in the morning, 11:09. By that same day that she sent, at 3:30 in the afternoon approximately, I got electronic access was provided by Matt, who said, good afternoon, Tom, and here it is, here's the link, so we could get on. So when the town council is being told, you have no electronic access to these documents, and the people are told you have no electronic access to the documents, well, we got electronic access to the documents, so it does exist. And I really resent the fact that our tax money goes to pay $100,000 for this, and God knows how many man hours we have with the town attorney, the town manager, and whoever else is involved in the collaboration to prevent us from, well, not prevent it, but I guess make it harder to go see these documents. So I don't know who has time to go and sit in the town clerk's office to go through 10,000 documents. But Lori and Donna went through all 10,000 documents once we had the links. It's much easier, you can do it at home. They spent countless hours on it, and that's where we're coming up with these documents. Well, not these two we sent on our own, but the first ones where they have the,
No, that's in the first
yeah, where they have the numbers on the bottom.
Right.
Thank you. So that's what I was telling you, the number on the bottom, that was put on by Burkham Moses, it's called Bates numbering. So every document they have, they got a number on it, and they have a paper copy, hard copy in the clerk's office. So when we're referring to stuff, we're referring to a Bates number, and so we know it's legitimate. I just thought you should know that what you're paying for and still being suppressed is the truth on a lot of this stuff. So that's it for that one.
Okay.
Phaedra, John?
Yep.
Thank you.
The mic is now working.
Oh, good.
Lori has the magic touch.
Thank you. Okay, so the next thing. Thank you for bearing with us, because, we're not professionals at this. So we're just volunteers trying to do a job. We take our job very seriously, and so we think we're doing some good. So anyway, the next poster, thank you. I wasn't saying for applause, but, okay. So the next poster we have is our page 8. It's going to be our page 8 on the YouTube, and it's Bates number Enfield 0035. And what I called it at the top of the page, it's a memo to Todd Helms from Ellen, the town manager, acting town manager at the time. And she also includes a copy to John Wilcox, finance director, and Steve Belinda, who was HR at the time. I believe he's still HR director, and he's assistant town manager now. So this goes from Ellen to Todd Helms, copy to the assistant town manager and HR director in finance. It's dated February 23rd, 2022. And it's a 3-page memo. I'm going to do 1 page at a time because it's packed with interesting stuff. Now, I called this at the top Enfield's War on Taxpayers memo for the town manager, the tax assessor, that we unearthed because he had to go some to find this. And the reason I use the word, the war on taxpayers, is when I first got asked to, I'd been on BAA for a number of years. I was retired from it. I'm happy, I'm home, I'm not doing anything else. And I got a call from the mayor, who was very concerned about the way the taxpayers were being treated at the time. And so he said, "Had I heard anything about the new tax assessor and what's going on?" And I said, "Yeah. I heard he declared war on the farmers." And Mayor Crusade said, "Well, no, actually, he's declared war on the taxpayers. He's declared war on the charities, nonprofits, Mount Carmel, homeowners, everybody, businesses." So he asked me to please go back involved again for the BAA because they wanted somebody with experience that also had some legal background, real estate background, so on and so forth. So I said, okay. So I then took that job and was privileged enough to work with Donna again and Lori for the first time on it. And so this particular document we just discovered maybe 3 weeks ago or so. And what the document talks about is, oh, you got, thank you, I can do it for you.
Okay.
Okay, so what the town manager is saying is the purpose of this document is because it's in response to community concerns about the way assessments have been done. The second paragraph talks about on February 18th, maybe you can push this closer to me? Thanks. Thank you very much.
Okay.
Okay, so the second paragraph starts off talking about they had a meeting on February 18th and discussed a plan to temporarily suspend.
Just trying to make it higher so
Okay,
we can
good.
go back and see it.
Yeah.
There you go.
Okay, this is to temporarily suspend revocations of tax exemptions until October 1st, 2022. And this was what she considered a purely administrative action, and they wanted to do it before the BAA process begins, you cut down on the number of appeals. So basically, she's telling Todd to suspend revocations until next grand list. So whoever you've revoked so far, that's okay. But just don't revoke anymore for now, because it may be too much for the BAA and for them to handle. Then he goes to the next paragraph, and she talks about specific nonprofits. And so she talked about Mount Carmel, over here, and she said that they had a meeting with the Mount Carmel Society, and that she felt that that they deserved to continue to have their exemption, and they had brought in a calendar, and she thought they were all set. So it's her expectation that their exemption is going to be restored. And then, remember, this is going to Todd, so she's telling them restored for Mount Carmel. And then the second one that she talks about is the Moose Lodge. And the Fraternal Order of Moose had been, was tax exempt for many years, at least 10 or maybe more. And however, she supports the conclusion of Todd that theirs should be revoked. And that's that. Now, meanwhile, she says they've had meetings with the Moose also for an hour and a half or whatever it was with their people and her people. So at this stage, both of those charities, Todd denied anyway, and he took their exemptions away. They both appealed to the BAA, and the BAA heard all the evidence and ruled in their favor and restored the exemptions. So, but the way it got there for the Moose Club, I think people should know what's going on, especially town council members. So, with the Moose, is it out there? Oh, good, okay, yeah, so the next screen over there, the poster, okay, that's a letter from the Moose Club, or Moose Lodge, Thompsonville Moose Lodge, dated August 4th, 2023, to whom it may concern. It's given to us, actually, with permission to use their name, talk about this, and let people know what happened to them. So the first paragraph, they confirm what I already told you. They met with the town manager, the assessor, and 4 other people to try and mediate their tax status with the town. When they met, they brought in a number of documents and gave 400 pages to the town. So the town has the Moose documents. By the town, I'm saying the town manager at this point. They left that meeting after an hour and a half and weren't sure if they were going to have to go and appeal or they were getting their tax exemption restored. But anyway, they left the word that if they had to appeal and had to go to the BAA, they wanted the manager and the assessor to share all the documents with the Board of Appeals. So when they did come in for their hearing, they saw Lori. I'm going to give this back to her in a minute. But they said in this, this would be the third to the bottom paragraph, where it says, oh no, excuse me. I gotta go point. Okay, right here where it says, I find it unconscionable that we spent so much time with the town manager and the assessor and provided them with so much documentation, they did not forward it to or provide any of the documents that we had given them. The reason that's important is when we take an appeal from taxpayers, it's the burden of proof is on the taxpayer. So if we don't have any documents from the Moose Club, they lose. So, and the last sentence in this is that we authorize the BAA to publicly discuss the matter, including the release of this letter and any other non-privileged material. So I'm going to give it to Lori now to tell her how we handled this appeal when they came before us.
Thank you. I highlighted this as one of my 15 issues. And if anybody was at the last meeting, and I pointed to this file that I keep saying that I gave to Mario Capolo and went over this for 6.5 to 7 hours, the Moose Club was one of the 15 that were in this file. I was so bothered by the whole thing that I lost sleep over it. These 400 documents were being withheld from us And I kept asking staff over and over, every time, where are these documents? They turn these documents in at the town manager's office. Does Todd have them? Does the town manager have them? Every single meeting, I ask the same questions over and over. I finally, on the second to the last day of our appeal hearings, I was, only after I said I was gonna go up to the town manager's office myself and look for them, I was told that I would be able to get them. They brought the 400 documents to our hearing. They told me that I could look at them, but that I couldn't take them from the building. So I literally had to stop doing appeals hearings and go through each one of those appeals. This was very important because unless we saw these documents, we would have had to deny them their exempt status. The documents proved that they were entitled to their tax exempt status, and we were able to allow their exempt status to continue. The BAA was returning to them what they already had for years. But then they were knocked out a second time, a second year in a row. But this time they didn't even really realize that they were being knocked out a second time. Again, I requested these documents. I was given them again just to look at. And even after I was told that I told the staff that the Moose Club stated that these documents were for the BAA, I was really so bothered that I actually mentioned this in an email to the deputy mayor, because I felt like the town manager was hiding documents that she was trying to get us to deny this tax exempt to the Moose Club.
Thank you, Lori. So I'm going to refer, well, what we just talked about is on pages 8 through 19 of the materials that you're going to get. And then one other thing I wanted to add, because I wasn't sure if the assessor was holding the documents back or it was the town manager, but in looking at the interview that the lawyers did with Todd, we took out excerpts, and these will appear in your package too. And if you look at Todd's excerpt on pages 25 and 26, he's asked about the Moose Club documents. So one of the attorneys, his name is Matthew. Matthew says, I wanted to briefly discuss the Moose Lodge. That issue, there was an allegation that the property owner, in that case, charitable entity, provided 400 plus documents to the town manager, and that those documents were ultimately not made available to the BAA. A request was made, and I believe they were told that Vicky brought the documents down on one of the last days of the BAA hearings, but the BAA members were told you can't keep these, so they may have had an opportunity to briefly review them, but they were not provided copies of whatever documents were provided. Do you have any recollection of this, or an explanation of the withholding of the documents? Todd, I do recall having a meeting with the Moose Lodge members, the representatives, the town manager, myself. They did bring in a lot of documents. You'd have to ask the town manager if she withheld anything, or that's really not a question for me. I wouldn't know what she did with documents. We provide the BAA anything they ask for. I don't know what else to say. I mean, if they ask for something, we get it to them as soon as they can. Certainly nothing was withheld with any malintent or anything like that. And the attorney then starts to go another area, and Todd interjects. I know one of the is actually their charter book. So it's not something you can really copy because it's a bound book. So, I'm assuming that maybe that's one of the things. And when it was given to the town manager, when it, originally given to us, they said they wanted the stuff back because, it's a book type material and stuff and everything. So it was never the intent of the town to keep it. I don't think Moose Club has it back yet. Do they? Does anybody here from the Moose? Do you have any of those documents yet?
I was one of the representatives that was at the meetings with them, and we gave them 5 years worth of my own personal calendars of everything we do. I had to go and I got the stuff back from Todd. He personally handed them to me.
When was
Just maybe 4 months ago.
Okay.
Those just my calendars, but all the other paperwork, like we put in our letter to you guys, was for you.
Thank you.
Thank you for clarifying that. Okay, the next one I'm going to go to is page 2 of 3. Thank you. Okay, on page 2 of 3, it actually started the page before where she's asking Todd about the number of farms that he's knocked out or changed use of or did some other 490 changes that he made. And but I'm not going to be bothered with it because I don't think his records are that accurate anyway. But what I do have is to go through is the BAA issued a report in May of 2022 that these things that she's talking about in her email, or yeah, in her memo, are the same things we talked about in May of last year that we were criticized for by the administration in terms of we were too harsh, we shouldn't be saying this stuff, and so on. So to continue on with page 2, she refers to an email, or excuse me, a telephone conversation she had with Joan Nichols. This would be page 28 in us, and it's page number 1003. And on this particular email, this is actually an email now from the town manager to Mario Capola in January of this year. And she's talking about a phone call she had with Joan Nichols of the Farm Bureau back on February 16th, a year earlier, that she had made notes from. And some of the notes that are worth looking at are, she does talk about Joan Nichols saying that it appears that Todd Helms had terminated classifications of 490 parcels that were granted by previous assessors, that they're working farms, and that Todd Helms decided to terminate on his own, and that some of these concerned woodlands, because he didn't understand that woodlands are part of the farm units as defined in the statutes. This is Ellen's notes, by the way, so she's commenting that Joan also believes that it's a direct violation of 2 state laws, which she interprets as meaning that previous classifications hold with the owners unless there is a change of title or change of use, which I believe is what Attorney Dubitsky explained to us earlier, which we all know anyway. And then that neither has occurred in their status as 490 should not have been changed or terminated. She then talked about how Joan said that the declaration of policy under the 490 legislation is to provide a tax benefit and does not force conversions due to assessments. Then she says, Joan stated, Todd has the 2020 Connecticut Farm Bureau Guide to PA 490 in his office. She commented that he wreaked havoc in Bloomfield 2 or 3 years ago. He ignored court cases. In the case of wetlands, farmers are trying to be good stewards and not fill wetlands. She then talked about some comments made by Kelleher and easy picking. So at this stage, I'm going to show you I'm going to tell you what she said first, and then show you what Kelleher really said. By the way, anybody we're doing this on, we have permission from them to actually bring their names up and say it, because even though it's public information, again, we're not going to invade anybody's privacy or make them feel uncomfortable. So everybody we're talking about, we've already discussed this with them and we have their consent. So now, if I can have the Kelleher, this would be, I think, 8. Is this one.
It's card 10. It's up.
It's up,
Oh,
it's on the
this-
bottom. Why I'm not finding it.
This
9
one.
and 10.
9 and 10 are there.
9 is top, 10 is bottom.
Where's,
Second one.
but where's Kelleher's? His is 880. That's the one I want. Thank you.
12A.
Okay, thank you. So anyway, this is easy picking, and it is easy picking. So Brian Kelleher, back in February of 2022, wrote to Ellen, and gave a copy to Matt Despard and Michael Ludwig. And he talked about a meeting that he had on the 16th of February with the town manager and the assessor. So when the assessor summarizes Kelleher as individual parcels in process for estate planning purposes, there's nothing about contiguous or non-contiguous farmland. That's it. That's the only mention she makes of this. But here's what really Kelleher told her. So Kelleher said that they began to discuss and review the change of assessments that Helms had made, and Helms thought that the difference was because of building values. And then when he looked at the cards, he said, well, there's no change there, and so it's not building. The assessor then stated that Brian Kelleher had 11 acres of woodland and 2.7 acres of swamp, edge, and brushland. The only problem is Kelleher doesn't have that on his farm. And then Todd had changed his soil to tillable C, which makes it more expensive for the farmer, not less expensive. At that point, Todd pointed to a map where there's some tilled fields and indicated that his parcel stopped there. Mr. Kelleher then went and moved the map so he could point to the actual parcel boundaries and showed him the parcel does indeed contain woods and woodlands. The assessor stated, well, he's been using Google to see the latest land uses and that Google doesn't include property boundaries. So then Brian Kelleher pointed out to the assessor that this property review made a significant revaluation, sent this revaluation out in a curt one-paragraph letter without explanation, and all of it is based on inaccurate reading of the town's map property lines. The assessor then stated his conviction that wooded parcels needed to have significant farm activity taking place within the parcel in order to be included in the farm unit. The statute clearly allows wooded parcels to be included in the farm unit. They don't have to be tilled. The assessor then goes down to the next one and he says, well, the assessor has the right to fix mistakes that previously occurred in 490 designation of parcels. This right is not indicated in the state statute, which clearly states the owner can only remove a parcel from 490 designation when there is a change of use or a change of ownership. Neither of those has taken place in the two wooded parcels being reviewed. And again, Attorney Dubinsky validated that again tonight. We've heard that so many times. It's in the Connecticut Farm Bureau book from 490 and so on. So Brian again says, listen, as a resident of Enfield, I believe the last two paragraphs indicate a lack of familiarity on the assessor's part of Connecticut PA 490, a statute that's vital in the performance of the assessor's responsibilities. And then he ends up saying that over the course of these decades, the local government has been extremely supportive and helpful. He actually mentioned Ginny Higley as being helpful 5 or 6 years earlier when they did some estate planning transfer from the mother to an LLC. And then he goes on to say that he certainly hopes that this email helps illustrate so our town can turn it around and get back to the values and quality our residents appreciate in their town. So he's sending this constructive criticism to her. He didn't go broadcast it on TV. He didn't call Paul Feinberg show yet. And so he's trying to make a situation better by letting the manager know what's going on. And again, her comment in her recollection of stuff was basically that they're individual parcels in the process of estate planning purposes. So then the next thing she talks about in this memo is the Agriculture Commission. And what she talks about in the Agriculture Commission is she mentions or states that they hosted Joan and the Farm Bureau for a meeting. That's the one also Attorney Dubinsky, I believe, was at. And her characterization of it is as follows. That was on March 3rd, 2022, and over 150 people attended. And then Joan went over the roles and responsibilities. Ellen says she was there to bear witness, and it was a, quote, pitchforks and torches, unquote, type of event, with many farmers coming to the microphone and castigating Todd. She then goes on to finish that, basically saying that she attributes this problem to a transition from the former assessor to the new assessor, and things were handled differently in the past, and it's a little different now. So with the Agriculture Commission, I want to show you what they really said. So there's two more, the ag ones.
11 and 12.
Thank you, Laurie. Okay. So here's what happened with the Agriculture Commission. The Agriculture Commission now, let's see, oh, here we go. So the Agriculture Commission on February 8th of 2022, they reported concerns on PA 490 properties to the town manager and to the Enfield Town Council. So all the council members got it and the town manager. And the first paragraph talks about how their goal or their mission is to educate and communicate on agricultural issues between the farmers and municipal officials so that they can reduce conflict, give advisory services, and foster a climate supporting economic viability of agriculture in the community. They then identify, right here, 4 major issues that have come up. And the issues they identify are qualifying properties that were being entirely removed from 490 program. Second one is land classifications or adjustments are being made without sufficient or advance notice to the property owners. Third is removal of woodland and wasteland from the farmland area classifications. And finally, that there were allegations that town employees were present on private property without notice or announcement, basically assuming trespasser status. That's my words on that, my editorial. So on July 11th of 2022, January 11th, 2022, the supervisor of assessment, Todd, was invited as a special guest to a regular meeting, and it was during their meeting that he then made other statements about removing other people from 490 and so on. So based upon what's going on with the 490, at that point, the Agriculture Commission said that when you take away 18 parcels classified as woodlands, 13 parcels as pasture, 12 parcels as tillable sea, and 10 parcels as forest, that's over 1,400 acres that he removed summarily without what appears to be any good cause. So if farms were removed or had qualifying acreage, then it appears to be an improper and erroneous interpretation. So to ensure proper implementation and compliance with 490 and reconcile the claims of affected farmers, they recommended he immediately suspend any further changes to 490, and they reverse them, putting them back where they were before he started it, that any further changes that he proposes that be done after consultation with outside experts, of which we know he didn't talk to anyone from the letter I sent him, including, though, the Department of Agriculture and the Connecticut Farm Bureau Association. So that's really what the Agriculture Commission with Karen LaPlante and others who have served so honorably here for many years, Mike Dynia and so on, that's what they recommended in a 2-page memo to the town manager. So hold on one second. Okay, so now back to Todd Helm's interview with Matt. Remember I read you some pages before, I'm going to read you a couple more now. This is Enfield 3588, Bates number. It's our page 20 through 24. I'm not going to read you the whole thing, but parts. So this is with Mr. Capola now. So Capola asks Todd, is it legally permissible for an assessor to enter private property for the purpose of an assessment without first obtaining permission from the property owner? Todd Helms, it is. 1255 gives the assessor the right to visit any property for a valid reason. My practice is to always knock on the door. If it's an occupied building, if there's an actual house on the property, vacant property if it's vacant, the assessor does have the right to walk on the property for a valid reason. So apparently, the civil criminal trespass and U.S. Constitution rights are suspended in Enfield for the tax assessor. Then you go to the next page. This is a different attorney now asking Todd Helms. Do you look at soil maps that are available online, or do you have a program with soil mapping? Well, I don't look at soil maps. I'm not a soil scientist. But what I looked at was the farmer, the same owner, has 2 properties on both sides of it. He claimed that those were tillable B, so that to the extent of my research, you know, if both sides of it are the same thing, how could the middle be any different? It's basically same type of soil and terrain going across it. Okay, and when you're dealing with PA 490 properties, have you ever consulted with the Department of Agriculture or reached out to the Department of Agriculture for advisory opinion? No. I gotta repeat that one. Okay, and when you're dealing with PA 490 properties, have you ever consulted with the Department of Agriculture or reached out to the Department of Agriculture for advisory opinion? Answer, no. These answers are being given about a year after the Agriculture Commission has made its recommendations about talking to some of these people before you make these decisions. So his answer is no. Then it's, are you aware of any property owners who have ever done that when there is a dispute? Okay. Well, have you found in the past advisory opinions to be helpful? If the Department of Agriculture issues an advisory opinion, then do you typically acknowledge and adhere to the recommendation of the Department of Agriculture? I've never actually seen a recommendation from the Agriculture Department as far as classifications go or values. I've seen some broad recommendations. Then he goes on and talks about, Joan Nichols, not to name names, but she's been the go-to person at that department. Now he's talking about the Agriculture Department. And it's been described, just thinking about how I actually want to say this, it's been described that she will take a Walmart parking lot and claim it as farmland because there's a farm market on it. So I mean, they may have a different goal than what the towns and necessarily, you know, the assessors do, but and role. It is the assessor's decision to classify, you know, farmland, not anybody else's decision, not the ag department, not the state department. It's each individual assessor's job to do that. So then Matt says, well, what you're referring to Joan Nichols, we interviewed Joan as part of this process. It's my understanding she's with the Connecticut Farm Bureau. So does that change your response at all with regard to reaching out to the Department of Agriculture, or do you find that, they often refer you to the Farm Bureau? I just never found a reason to reach out for them. And then the next page talks about 490 as a use statute. And now the people that aren't farmers probably going to be farmers by the time you're done attending this one, whatever else we have. So you've got to know all the language. Okay, so Matt says, well, clearly 490 is a use statute. You know, you can't, the intent is clear. You don't look at the highest and best use. You can't take farmland and, you know, assess it as a residential subdivision or commercial lot, correct? Correct. So then Todd Helms then talks about, well, I would say the highest classification of what the property is. Then he goes on wandering a little, and then he comes back and says, so you're going to classify it once as what it should be, you know, the highest and best farm use that it can be, and it stays there. It doesn't change year after year unless something catastrophic happens. So he basically now, when you're not supposed to take highest and best use, he now is taking highest and best farm use. Is there any such thing, Lori?
No.
And you're an appraiser.
Yes.
Thank you. Okay, so then, to continue on, have you ever consulted with soil scientists? The answer to that, I gotta start this way, excuse me. Okay, and in your experience, have you found that farm owners are typically honest and forthcoming about the classification of their property? Then he goes on and says, have you ever consulted with soil scientists? Todd Helms answers by saying, well, the answer to the last part is no, I never consulted with soil scientists. I don't review 490 all that often. And then he goes talking about other stuff, but he never answers the first part about, does he think farm owners are typically honest? So he never answered that part of the question, but when he was at the BAA meeting in March, I think it was this past year, he did tell us that taxpayers lie. We then said, and I remember me saying it, is that, well, actually, we found taxpayers to be candid, forthright, and honest, and we start off treating everybody that way unless it's proven differently. But I was taken back by an attitude of taxpayers lie. So that takes care of the this part of page 2. Excuse me. Yeah. Okay, I think the next one is, yeah. Oh, you know what I'm gonna do? Next I'm gonna do motor vehicle, other years. Okay, the next part.
Bang it.
Now, this is why I did this.
Take a break and fix it.
No, I had called my husband for some batteries before, because we were getting low, I could tell. Wait, we gotta wait.
Backwards.
It's,
Okay. You can put that page 2 for memo, and then this one.
Okay.
That's good, thank you. Well, anyway, I'm gonna get started on this. So, to go back to Ellen's memo of 2 out of 3, the next thing she talked about, is a letter that she had gotten from Attorney Hollister that actually went to the town, and the town assessor took on the responsibility of apparently, town assessor took on the responsibility of discussing with somebody a legal matter, an Attorney Hollister, on rainbow housing, which according to Ellen, the fact he didn't tell the town attorney or anybody else exposed the town to some liability. So she said, if you're gonna do that again, I mean, you gotta give it to the town attorney. You're an assessor, not a lawyer. Then she goes on to the next paragraph where she talks about being contacted by 2 companies in Connecticut with regard to motor vehicles. And if you bear with me 1 minute again. Do you have that page?
I'm looking for this one here. Is that
Page 2.
Oh, no, page 2 of her?
That's page 3, yeah, I'm over
Oh,
page 2.
I got it. Here.
Thank you. Okay, I got it.
Oh.
Okay, so down at the next paragraph, she talks about, she was contacted by 2 companies regarding his letter about motor vehicles. And in the letter about motor vehicles, want to get a copy of it? Yeah, thanks, if you hold that up. So what happened is, Todd had sent out a letter to people in February of 2022, where he said he had been notified by the motor vehicle department that there has been a recent transfer on a vehicle, and that so he wanted them to report everything and fill out this form. and also give you a copy of your bill of sale. The problem, of course, is that never happened. He never got anything from the motor vehicle department. He made it up in order to get information from people. And this is the letter that he put in his documents, which the town has, and we get a copy of. And it's addressed to somebody, but it talks about a motor vehicle. It's a 1995 or 96. So a lot of people were getting these letters that were bogus. And then what they did is they apparently complained to the town manager, who said that that after she had gotten them, that here's her words now, that representatives were confused by the wording of the letter, since many of the commercial vehicles had been duly registered for years. The one company reported that you told them failure to report would result in you making the assessment of what the body type was, and that you would choose the higher value. Another expressed concern about the impact this recent and hopefully temporary surge in used cars is going to have on people. So that being done, when we did our hearings, you can see this in the bottom half here, that's from our report in May of 2022, after hearing the same thing from a bunch of people, that, I got it,
Yeah.
thank you, that we actually commented to everybody saying that one of the tax assessor's more disturbing methods used to obtain information from personal property owners was a false assertion that the state motor vehicle department had notified our office you recently registered a low motor vehicle in Enfield. So in effect, the state notice was a concoction, it never happened, and that we thought this, he used this as a predicate to launch an inquisition against scores of unsuspecting businesses and property owners regarding the hundreds of motor vehicles for information they did not otherwise would have been, they wouldn't have had to obligated to dig up and turn over to the tax assessor. His methods were described by some as devious and deceitful. Now remember, everybody that we see before us, we swear them in. They're all sworn in, so they're telling us, you know, this under oath. And that one complained he thought his identity had been stolen. Several thought it was mail fraud. And so we notified the town council and the manager and so on about this in our report. Then the next part of, if you look at the top part of this, it talks about equitable estoppel, and what had happened is some people had open spaces like Grassmere has of a water company where they have their wells. Open spaces have been granted to these people for, in some cases, 50 years or more, 5 or 6 assessors previously. And so the town now seemed to be adopting a position that we don't have a formal open space policy that's been accepted yet, so therefore we're knocking everybody out. And we looked at that and said, well, we're familiar with what's called an exception to the doctrine of equitable estoppel, which basically means that open space and property owners that were induced by the town, including former and current assessors, and reasonably relying on past representations that now threatens to subject them to substantial loss if the town goes through its tax assessor's office and they're permitted to negate the acts of former or current agents, especially without substantive or procedural due process. We thought it's wrong, and also it subjects the town to tremendous liability. So we restored open space to Grassmere, Hasville Water Company, and so on. And that's some of the ones that he then revised and took away, and then some of them came back to us. But anyway, that's one of the other parts of our decision that we made. And then the next thing that is in Ellen's report is she talked about inspections on farms, and she has that somewhere in here, but she talks about the inspections but kind of poo-poos it a little and remember what we had heard from some of the other people previously in other testimony, like Connecticut Mulch, where he just showed up, Jarmach, Antonacci, Delorge, Kogut, Longi. And I want to read you what Lori Longi's situation was. But everybody I just mentioned, he had showed up at their property, no announcement, no permission, no nothing, just they caught him roaming around and asked him, what is he doing there? They don't know who he is. And then here's essentially what he did to Lori. So she forwarded this document, which is page 32, to Mario in an email so that he would know what's going on with this depreciation and some other issues that he didn't cover during her interview. But here goes on just this part about the inspection. Mario, when you asked me the question prior about being on the BAA, if I had any interaction with Todd, I answered you thinking prior to me on BAA 5 years ago, and answered regarding Bloomfield for my first encounter. But actually my first encounter, now that I think about it, was my own home and farm. One Friday afternoon about 3:30, Todd showed up in the backyard of my property. I remember the day well because I was playing with my grandson at the time. He was around age 2.5. My property is and has always been posted no trespassing for years. Todd started walking up to me while we were at the playground area, and I said words to the effect, "Can I help you?" And he said, "Well, I'm the tax assessor. I'm here to inspect your farm." Then he said, "Do you file a Schedule F on your personal return?" I said, "We file for the farm, but we're also a corporation." And he wanted me to go in and get a copy of my tax return. I said, "I don't have my information here. I'm outside with my grandson, but any request, put it in writing and send it to me." At that point, my husband had come around from where he had been working on the farm, and he saw this strange guy in our backyard with me and my grandson. I said, "He's the assessor and he wants to look at the farm." So David pointed over to the greenhouses, over to the back field, and he said, "You just cut down the hay." So they walked over to the field, and on the way back, Todd said to me, "I'm knocking out all the farms in Enfield, and so if there are 100 farms and 50 appeal, then I'm still ahead. I'm knocking out the goat farmer down the street." And Lori said, "I don't know of any goat farmer down the street, and I've lived here my whole life." I said, "Do you know I sit on the BAA?" On Lori Longi, he then walked up to his car, got in, and left. That was the first interaction with Todd. So, and with the BAA, yeah, thank you.
Sorry, I was waiting.
Yeah. Okay, so another part of our report, just at the end, this is where we commented about a disturbing activity or tactic was the manner in which the tax assessor conducted farms, real estate inspections. As a general practice, he just appears, no prior notice or request for permission, begins roaming around until he's detected by the owner, and then once confronted, demands immediate access to inspect real estate. It matters not whether the property is posted, fenced, gated, nor did it matter whether his timing was inconvenient for the property owner. As justification, he'd say, "Well, I'm the tax assessor and I'm here to inspect the property." So we said this is not merely a matter of being impolite, rude, thoughtless, or inconsiderate. It's much more than that. The tax assessor's unannounced appearances many times placed him in the status of a trespasser, and these tactics created situations ripe for conflict, confusion, and confrontation. So with that, that takes care of, I think, page 2 of her memo. Okay. Now, pardon me for 1 minute. Thank you. Put this stuff away. Did you see page 3 around?
I have it right here, right now, if you want.
Okay. Thank you. Okay.
Oh, this is,
I'll use yours.
this is right here.
Thanks. Okay, so, page, yeah, thanks. Okay, thank you. Okay?
Tom, next time just hand it to her, don't put it on the table.
I know, I could just grab it.
You're welcome.
Until you put it down, it stops working.
Okay. Thank you. Okay, so now this is page 3
Yeah, you are.
of 3. And I want to tell you, remember, she's throughout this talking about pausing, stopping what he's doing, but not ending it, not reversing it, just pausing until the next grand list. So then she starts off on this one on page 3 of 3 with her conclusion, and she wants what I consider delayed implementation, because that's to avoid or at least reduce the number of appeals. That's her goal. And that'll help also because it would then, delayed implementation of revocations will provide greater due process, equal protection, and avoid lawsuits, and to put the town in a much more defensible position. So that she then said that I take it that then you're going to accept my recommendation for pausing on nonprofits, group homes, and farms for soil classifications, and you're going to pause on Department of Motor Vehicle dissemination of the letter that you had going out. And then she talked about the Office of the Town Manager and Town Attorney will work with you and your staff to create media and communication strategies moving forward to advertise, inform, and educate Enfield residents and businesses. And that struck me in terms of, it's almost like propaganda that people are now having the town attorney and the town manager collaborate and work with Todd so that they'll create this media perception. And in some instances, I'm sure you've heard, perception is reality or becomes reality. But I was taken back by that. She then ended up saying in this memo, I would prefer this to be a collaborative process in which our administrative team works together to solve the many problems that have arisen from the abrupt revocation of tax exemptions that have been in place for many years. Whereas she's right, I think that it's an abrupt revocation of tax exemption and it's a problem. I'm amazed that she thinks that the assessor's office should be a collaborative process where you're going to involve the zoning enforcement officer, inlands, wetlands, building department, town attorney, and any other group that you're going to have. They used to call that a star chamber from when I grew up. So basically she wants him to confirm that he agrees with her analysis, the 3 pages, and he's going to delay implementation in the areas we've discussed. So now remember, the Agriculture Commission suggested suspend and put it back. She does it pause and then go forward next year. So this is my interpretation, it's not the board's at the bottom, but basically the 3 pages I concluded this way. First, the instruction to Todd is continue screwing some of the taxpayers all the time. Continue screwing all the taxpayers some of the time, but do not continue screwing all the taxpayers all the time. Because when you do that, too many of them are here, like tonight. Okay, thanks. Now the next section, this is going to be page 37 through 40. I want you to know how you ended up with this law firm as the law firm to handle this investigation, so-called. Because it starts off, well, first of all, the law firm got hired, I believe it was like August, late August of last year. But prior to that, on June 15th of 2022, in Enfield number 0065, the Bates number, our pages 37 through 40, there's an email from James Talbert, but it's from his law office. It's not from the town attorney's office. It's to his friend Mario Capola. Mario, do you have a minute to touch base about a potential new matter that a client of mine may ask you to consider? Mary then sends back, and again, to Talberg's law office, private law office, not the town attorney's office. Jim, I didn't respond sooner, but I was at kindergarten graduation this afternoon and then dinner with my family. But I'm available tomorrow starting at 8. Please let me know your availability and best number to call you at. Then they had a next day, again, Talberg's private law firm, not the town attorney's office. Hey Mario, I'm here at the office number. How about a call around 9:30? And then, yep, that works for me. I'll call you at 9:30. So now, Jim Talberg is making a referral to a friend of his, and he then continues with the next email we have. Mario, we have a council meeting in Enfield Monday night, and the agenda is being finalized as we speak, but we're going to have an agenda item that reads, request for a bid waiver to retain independent review of revaluation issues. I have been given authority by the town manager and council leadership to retain Burkham Moses for this purpose. So there may be council people here today that did not know that council leadership and the town manager gave him authority to do this, but he's still using his personal law firm rather than the town one. Then asks him, a formal retention agreement can come later, but can you please confirm you don't have any conflicts? Then he sends him an email with a bunch of people to check out and make sure he doesn't have any conflicts. Again, from his private law firm the next day, June 16th. During Cupola, here's a conflict list. And he lists the town of Enfield, Board of Assessment Appeals, tax assessor, assistant assessor, me, Lori, Donna, and the town manager. And then he says down the bottom, pursuant to town charter, we're probably going to want to see a bid waiver to be approved by town council since expenditure will exceed $15,000. And then the next thing is he gets an email back from Mario. Jim, I conducted my search. I'm pleased to report we don't have a conflict. Anything further you need from me? And then Jim sends back, and this is, I think, very revealing. Perfect. At some point next week, if you please, send me a retainer letter, and we should be all set. Thank you for agreeing to assist us in this matter. Look forward to working with you. That's what you call collaboration. That's not independent. It's dependent, working together jointly. So when they say, oh, there's no connections with anybody with this, and it's independent, you can quote him in his own words. Thank you for agreeing to assist us with this matter. Look forward to working with you. I just thought that was revealing, and I'm sure they didn't want that to see the light of day either. Then, page 41, 42, we have some emails from Talberg, Ellen, Helms, and it's all on, and they mark it privileged and confidential, attorney-client communications. And what they talk about is, Todd, I've been taking a closer look at the above property, which is reduced to 0 by the BAA. I can't look at that property on Vision. And they go on, and this just shows there are maybe 500 pages of obsession with Lori Lonke and this one property that they're trying to manufacture into a major problem. And again, the reason they're obsessed with her is she's the only one that's a certified appraiser in the state of Connecticut that has anything to do with all this stuff. So she presents a danger to them and their the way they did Vision and the whole thing. So then I want to then come up with, and I realize we're getting a little bit late. I appreciate people staying. You don't have to stay if you don't want. You watch on YouTube, but we're going to finish this so that people can know we may not get another chance. In fact, I'm surprised they didn't shut us down tonight. So anyway, I want to have this one, which is page 43 and 44. It's Enfield numbers 996, 997. And this is a email, and it's from, starts off from Ellen to Helms and Belinda. And again, privileged and confidential, meetings with Mario Cupola. And then one from Helms to Ellen and Belinda, privileged and confidential, meetings with Mario Cupola. And then Ellen to Mario, talking about meetings with Mario Capola. They had many, many meetings that you won't find anyplace. But they had meetings between all of these people to put together whatever their story was before they interviewed us. And so what it talks about is on these is that she's asking for, she is Ellen, asking Todd, was there any documentation such as emails or notes from Vicki or other staff over their level of discomfort with how the BAA members were treating them and talking to them? Do you have anything that we could forward? I've asked Steve, human resources guy now, to go through his notes and emails. I have a referenced item on the list that I kept hearing, but he basically, it's from a conversation you and I had. So Todd is the one that's telling her this. And then his response to that is, all of our communications were verbal. I don't believe there was any written communications regarding this. Mario should have a brief talk with all the staff here though, so he understands the complete situation. Then it goes forward and ends up with this for Ellen. Well, did Mario ask you to furnish copies of any request letters we had? That's because my homework list is, she has a homework list, as does all the rest of these people, for what Mario would like them to do before they're going to talk to us. So basically, you got to get the ammunition before you're going to fire it. And then she ends up saying, thanks, and let me know what you may on the above reference items, so I may respond to Mario and or we can collaborate. So once again, she's collaborating her 3-page memo. She's collaborating here with Mario, and it's supposed to be an independent investigation. So what we've concluded is collaboration to me means when people are working together for a common interest, and the common interest here was to clear the town, deflect blame, and come up with a predetermined result. So with me, I mean, I didn't want to know what to name this report. First I was made some area reports, Capola reports, this report, it's the rigged report. So from now on, I'm referring to it as the rigged report. So then she has in her notes to Mario, January 24th, 2023, here's the farm book that you requested. In addition, I remembered, or I discovered I stored a lot of relevant notes that I made in it and during the initial discovery process. So I made copies and included them. Well, when we went through the documents, there's a lot of stuff there, but there are none of her notes. So I don't know what happened to them. I'm going to breeze through a couple of these things, but one thing I think is important is before Helms was interviewed, he sent a series of emails to Mario, basically telling him what he wanted him to be asked and his homework assignment. And the homework, one of them is this, that he's telling, Mario must have asked him, are you licensed, like I say, certified assessment evaluator? Todd's response is, though I've taken these tests in the past, I need to renew my certificate form. Once complete, I'll be able to take the course study and exam again. So that usually means you didn't pass it. Then the next page he's got, this is our page 47. It's got the certified assessment evaluator. We don't have posters on all of it because it's too expensive to do that. But anyway, this is now Todd's handwriting where he says he taken but not completed. So he didn't complete income approach to evaluation or income approach to evaluation 2. But he's going to take it again and sometime. Then this is now a series of emails that I found even more disturbing than that. And that is pages 48 and 48, 49, and 50. But here's what it is on page 48, Enfield 2004. It's an email from Councilman Santinella dated May 9th, 2022 to the town manager, and says, regarding out-of-state license plates. Ellen, one thing I forgot to mention this week, and I took a ride around District 2. He's a District 2 council person, for those who don't know it. I took a ride around District 2 and started counting cars with out-of-state registrations. I stopped counting at 235. Most of the vehicles were in some larger apartment buildings, like Bigelow, but many were in people's driveways. This is a huge issue for the town. This is additional tax revenue that is owed to us. What are we doing about it? Then he gives her a heads up he's going to be at the meeting, but it's like he's a District 2 representative for people in District 2, and he's riding around almost like he's stalking out-of-state plates that may be visiting. I mean, we're a border town. It's Massachusetts. You have friends, you have relatives that come down. Are you now going to get billed for your friends and relatives that come down for their cars? You think not? Listen up. So then Ellen sends it off to Helms because she wants him to do something about this. So then the next thing we have is, it's Sandell's pet project apparently is this. So now Todd Helms sending, whoops.
I feel like you're like
Okay.
one of my kids.
So Todd Helms sends a memo to Mario in response to this license plate out-of-state cars. So the part that's the most important is he created a spreadsheet for him in terms of unregistered motor vehicles. And here's what he says. This increase is because we have greater diligence reviewing CITUS accounts. The biggest increase was the discovery of around 120 commercial trailers that have been registered in Maine. They were for several companies, but all had the same Enfield mailing address. In reality, they're all owned by the same entity, just with different business names. I added these going back 3 years to the grand list. The BAA, however, removed all of them. I had several communications and emails with representatives of the company. They refused to tell me where their trailers were or where they were taxed. All he would say is Enfield's not the place where they are most frequently leave from or return to. It was obvious they knew the statute regarding this. So they knew what the law is. They didn't have to tell them. And they're not trailers that come here or stay here or leave here or go from here. So he's mad at us because there's 120 trailers registered in Maine that he's not able to get tax money on for the town of Enfield. So then we find out who the trailers are belong to. So the next email he has is, this is again May 31st from Todd Helms to Ellen with regard to the same Santanella issue that he keeps bringing up. And he says, please note the BAA granted the taxpayers appeal that 130 trailers, so now it's grown. So maybe it's like rabbits. So now they got 130 trailers registered in Maine. The BAA removed all 3 years of tax bills for them. That's a loss of nearly $200,000. Now I'm going to tell you how he ended up with these people and going after them was, he, Todd Helms, went to their farm, which is on the border of Enfield and Summers. This is the Antonacci's, and they have horses. And so, and I confirmed this, we have permission to talk about this from their lawyer. And so he told me I could, and I want to get it exactly right. He said that all of a sudden one day, they find Todd Helms in a stable where there's horses and there's trainers. And in the horses and trainers, he identifies himself as tax assessor and he's here to inspect the property. These guys don't speak English. So fortunately though, it's on cameras. So the Antonacci's see it from their home base and they end up either going over or having somebody go over to confront him and say, what are you doing here? They're concerned about the safety of their trainers now because the horses are skittish. They're concerned about his safety and they're concerned about their horses. So they tell him, get out of here and make an appointment or something. But once you do that, then he gets angry. So what he did is he then removed a lot of their 490 designation reclassified their land and increased their value on that. But here's what else he did. He then went and found this 130 or 120 trailers that are owned by the Antonaccis, and they're registered in Maine, and they're not here in Enfield. But what he did is punish them to now hit them with that tax bill. The third thing he did is he went to a solar carport that they have in on Mullen Road, the solar carport that at their business, and he then revoked their solar exemption and instead left them with another, might have been $900,000 extra tax bill or something like that. So when they came to us, they had all sorts of proof with regard to the their solar carports as well as the other stuff, and so we granted them relief. And this is one of the things that's in the report, as though the BAA really screwed up here, because you know, we shouldn't have given them the solar carports. They had the solar carports. This guy took them from them. We merely unscrewed them. So they got their solar carports back. And but yet we're criticizing this report based upon that. So let's see. Yeah, well, yeah, I'm going to go away from it slightly, but just to keep moving. So page 51 talks about how what Helms did. He's reporting this to Mario about motor vehicle with VIN code. And so the reason that a lot of your vehicles went up this year by about 30% is because it's actually 28.6% according to him. He said that he instituted a new code here program called VIN code in 2021, whereas the predecessor didn't use this program. This program comes from some assessors statewide that use it, and it takes down average cost of vehicles, so on and so forth. And then he says that this number that he got is a good indication of the value, in other words, the tax dollars increase realized by him using this new technology. But he ends up by saying, and this is to Mario, it is confusing, and I hope I've explained it enough to muddle through, but the yellow highlighted cells at the bottom are the estimated tax dollar increase. So everything he does is, no, I shouldn't say everything, I take that back. But it is, we found significant evidence of more manipulation of numbers to artificially increase grant lists or people's values so that the town gets more tax dollars without raising the mill rate. Okay, now, this next part, I just got to read, because it's amazing. So now Todd is being asked, this is more excerpts, begins at page 54 of our handout. And it says, this is from Mary Coppola. For the BAA hearings that you attended, what were your observations? So Helms says, well, they were handled very unprofessionally. I don't recall anybody even being sworn in. Now, I think a lot of people here were there for hearings last year. Was anybody not sworn in? I mean, this guy tape recorded it, and he still doesn't know we're sworn in. The only one that wasn't sworn in is him. So anyway, he then goes on and saying that there was no flag in the room, and they didn't even do a Pledge of Allegiance. I mean, to what? An empty hall? Amazing. Then he talks about, Coppola says, well, let me give you another homework assignment. The reason I keep telling you this is the collusion, or not collusion, collaboration that's been going on with all these people is astounding. So, Coppola, let me give you another homework assignment. You give this to Vicky, by the way, too. And then he says, I want to see all the public notices. This is Coppola now. I want to see public notices, agendas, minutes, meetings, public notices. I want for all of them. Matt, let me ask you something. You've gone through this. Did you see any of these records? Are they any place? And then the guy says, yeah, we talked about that with Ellen. Oh, okay, so Ellen's got them? No, they're online. And then he goes on. And then Todd says, this report that we did, he claims, Tom states in his manifesto, so he calls our report a manifesto, that in the deliberation, they took notes and I don't see where their notes are, and they shared stuff between them. So now he gets back to, can you tell me what your observations were about the BAA? They didn't follow the rules, very unprofessional. Then, here's going to get to the best part. So he says that some of the questions, they're leading from Tom. I mean, I basically sat behind Tom for the most part, and they were certainly questions to the taxpayers. I mean, they can do what they want, but it just seemed very unprofessional to hear the facts and what the person wanted. So I know he screamed at me at one of those meetings. He screamed, he is me. Okay, so he screamed at me at one of those meetings. I mean, it wasn't the taxes hearings, but one of their special meetings. I mean, he literally, I think he actually just got out of his chair and just screamed at me to shut the hell up. So Capola said, oh, so tell me about that. What happened there? Well, so one of the first meetings I was there, and it wasn't one of the ones being recorded because we weren't thinking about that at the time. And he asked somebody a question, and I just had knowledge of it and stuff and everything. So I started to speak up, and he just, I believe he rose up out of his chair. Well, he might not have. But I mean, basically, I started to say something in a public hearing. I mean, I wasn't, well, you know, I didn't have the floor or whatever. But I probably shouldn't have said, well, he just basically just screamed at me, shut up, shut the hell up. I don't want to hear anything more from you. I'm done with you. I'm paraphrasing, but it was something like that. So Capola says, what did you say? I believe it was just, you know, some of my staff members, you know, she was asking me something about stuff, and it was because Vicky couldn't do the secretary stuff because here at a portion, and they were asking something, you know, with somebody else, and I started to say, and we have a part-time girl, and so then the guy's, you know, like trying to get him to, you know, what did you say? So, and then Helms says that Belinda was at the meeting. So Capola says, okay, so Steve Belinda was at the meeting, okay, and how did you respond to his request for you to shut the hell up? Helms, I shut the hell up. You can't make this up. You can't. So I didn't write this for him, though. I just want you to know I didn't do it. So then Belinda, he says, well, did Mr. Belinda have any comment about when you were done? Well, he wasn't there. They already told the guy he was there. Now he's not there. I mean, he was not in the meeting. So Capola, well, did you have any discussion with Mr. Tyler after the meeting to confront him with regard to his interaction with you at that meeting? I did not. Well, aside from not confronting him or in person, I guess, or on the phone, did you like send him an email or in any way document what happened? I did not. Okay, so anyway, so you said Tyler was asking leading questions. Yeah, he was asking questions about valuation. Have you ever heard anything like this before? I mean, so now he says, it's getting too long, but it's okay. So and then he goes, one of his biggest statements was, and he always said this just about every hearing to everybody, he said, which is fine, he said, well, listen, you're the owner of the property. Courts have decided, you know, if you own the property, you have a legal right that you know what the property's worth, and, which I believe is accurate. I mean, I believe the courts have stated that, you know, if you're the owner of property, you can certainly state what you think your opinion is of the value, but it certainly doesn't make you an expert. So that's his observations of our meetings. So then I do have, is this a poster?
No, we don't have
okay.
any.
Okay, so I do have,
It is posted.
it's a poster, okay. This is now an email from Ellen to Wilcox and Helms, which talks about Jarmark and tax stabilization plan. Now, this has been a big deal with them too. So in the email, Ellen is sending to Wilcox saying that Attorney Capola wants a tax stabilization plan. And the reason is, right here, talks about, Todd, didn't you reference the fact that when they came before the BAA in May of 2021, John Ungehier was chair and the BAA voted 3-0 to not grant their appeal? This is Jarmark. And then 1 year later, with Tom Tyler replacing Ungehier as chair, but the other two members the same, they voted 3-0 to sustain the appeal. appeals 17, 18, and 19 as the properties weren't combined yet. 3 appeal applications and work papers as well as the minutes. So then they get it back, and by the way, it's privileged and confidential, so I'm sure they didn't want anybody to see this one, page 61. So then it goes now from Ellen to Mario because they got us. You know, we did something really bad on Jarmark, they think. What they fail to realize is that the town has a tax stabilization agreement. They get X amount of dollars. They actually get $320,000 a year, approximately, on these properties. And in return, that's for all of the real estate and personal property that's on there. They get that for the next 20 years. So the year it came in, Jarmark had come in with an appeal seeking to change the land to PA 490, which would have given them a different classification and a different tax number, which would have been a decrease in taxes because it would have been a change. However, the board then, with John Ungerheier and Lori and Donna, were told, here's a tax stabilization agreement. They can't do this because it's got to stay the same no matter what happens with this property, unless there's certain ways in there you can modify it. So they voted 3-0 to deny Jarmark's request to decrease taxes based upon a 490 application. The following year, I've taken the place now of John, he's gone, I'm there, and now in comes the town of Enfield, and they say they would like to increase the taxes on this piece on Jarmark. In part because they're mad at Jarmark, because again, Todd went over there on their property, they threw him off, said you gotta come back some other time, and so from then on, he's retribution against Jarmark. So with the town coming in and the same rule with tax stabilization, we're saying, well, we didn't decrease taxes, we're not gonna increase taxes, you're still getting $320,000 a year, and that's what the deal is. So in 2023, the town comes back and does the same thing. So we're thinking it's the same town claim, same precedent, same result, and either the town doesn't understand their own agreement, or they intentionally misrepresent it when they find it convenient to try and squeeze somebody for more taxes. That goes on for about 8 or 10 pages, and one of the reasons they also said was because that the lots have not merged. And so now Lori can talk very quickly about the merged lots.
So when the Jarmarks came in for their appeal, they had an email from Rick Rochelle, who is the zoning enforcement officer, which said 65 Broadbrook Road, which by the way, doesn't exist anymore since it was merged with 69 Broadbrook Road. So I actually put on their appeal, per the ZEO, email dated April 6, 2021, from Rick Rochelle that the ZEO, that this lot was merged into the lot of 102-48, which is under the tax stabilization agreement for the appeal of 307, 308, and 309. Now to be included in the appeal is 310 due to the merging. And so then I actually, when I met with Mario Capolo, explained that I sat on the zoning, planning and zoning for 8 years. So I understood all about how lots get merged into another lot. I believed Rick Rochelle, that is exactly what happened. So it merged into the lot with the tax stabilization, so obviously we couldn't charge them. It now became part of this tax stabilization. So that was well documented in our files. Among other things, we well documented each and every file. I do not believe that the investigator, Mario Capolo, looked at any of our files. He Bates numbered them, but he didn't read them. Because all of this stuff that we're talking to you, it's all in the files. It's in our 6,000 page document file that they sent through the scanner and numbered, but they never read anything that we put in there.
Thank you. Did you show them the email from Rochelle?
Oh, I had
Okay.
it. Yeah, it's in the file.
Yeah, there is an email in there where Rochelle actually tells Jarmark that these properties are have been combined. So the tax assessor doesn't have the right to uncombine them either. But he doesn't have the right also to his own statement of facts that are wrong. With, to get back to Antonacci's for a second, when you get to them, you'll see about the solar carport. That's about 10 or 12 pages from like page 71 or 70 on until 80. And that includes their prior permits. They also, the town of East Windsor tried to, the assessor there tried to knock them out from a solar carport, and that was reversed by the Board of Assessment Appeals also over there. So all of this is evidence that we had and we included in our package, but there was so much more. We had probably had 50 pages worth on it that we go through and look, well, Lori did that one, but it was great. So now anyway, now I want to get back to we're up to page 81 now. There's only 7 pages left. So on page 81, which is town 0089, it's another email from Talberg to Mario Coppola. This is dated December 5th now of 2022. Privileged and confidential. And remember, this is independent except for when they're collaborating. So Mario, here's a news report concerning property at 78 Park Avenue. That's David and Lori Lange's property. You may recall on May 20th, 22, the BAA chair granted a tax appeal reducing the assessment on this property to 0. Noting on the appeal form there was no marketable title and the property owner, BAA member Lori Lange, recused herself. Well, the problem with that statement is I did do the hearing, we deliberated, Donna and I, Lori did recuse herself, but I didn't say the property was 0. What we said was, because the town had perpetuated a title problem on this that they had just discovered, and the town refused to correct it, they had no marketable title. Very simply, there's 5 words. They do not own it. So, does anybody here want to pay a tax bill on property you do not own? So, we put that in our decision. They don't own it. However, we said, and I know that Lori and David were working on trying to get it better, we said that in the event marketable title is restored, we said it's going to be worth $40,000, not the $60,000 or $65,000 that the assessor had put on it. And the reason we said that is they had a buyer with a contract for $40,000, subject to getting approvals from zoning and so on. So at the time, and then they got their marketable title restored, so the property's $40,000. So as of October 1st of 2022, the fair market in that property is $40,000. This is written after that in December of 2022, so Talberg knows or should know it doesn't have a 0 value, its value is $40,000. Yet, he puts this in the email again to Mario. Query, how much Ms. Lange is selling this property for, given that the BAA, of which she's a member, concluded it has a 0 value? Again, the town made the title unmarketable, then refused to fix it. Talberg either didn't read our decisions or minutes, or he intentionally misrepresented it in order to improperly influence a guy that's doing this investigation. Then I want to read some more of Todd being interviewed by Coppola, and yeah, this is all Coppola now. So, Coppola, were there any prominent property owners involved in these appeals? Helms, yes. And who are they? And I'm going to just name, because it's a long answer, but Jarmark, Connecticut Mulch, Antonacci, and with Antonacci's, he makes a specific point to them. It's the Antonacci family. Now, the Antonacci family doesn't own anything in the name of the Antonacci family. They own a lot of different businesses and some companies. But it bothers me when he says, what's the Antonacci family? So then he said, which is my predecessor's own family, and while she's married into that family, just to complicate things. And I did find a letter right in front of me, if you got any questions. And then, so what we noticed is this pattern of retribution on anybody who resisted his authority, then he retaliated against them. We found evidence of that and reported it in our decisions to those people, including Jarmark, Connecticut Mulch, Antonacci, Delorge was another one, and Longy. So now he gets into Longy with this 78 Park Avenue thing they're trying to manufacture this big deal of. By the way, the taxes on it are $500 a year. They had to spend $200,000 on digging up crap to put in this. So anyway, Cupola. There's an appeal that she was filed, by David and Lori Longy for 78 Park Avenue. The appellant had a value of $5,000, so it looks like the owner filed and the assessment was taken down to zero. Are you familiar with that application? I am. Well, what are your thoughts about it? My thoughts about it is it could be criminal in their decision. Why? And then he goes in and says, because it was unsellable because of a title issue, but the owner purchased the property first sold for a set amount, so obviously it had some value to her. Then he goes on and says, well, when did Ms. Longy purchase the property? Cupola says, well, Todd says, I don't have it in front of me. Cupola says, well, I got a document in front of me. Looks like she bought it, looks like April of 2022. They actually got it in 2016, but it shows me, Cupola, he didn't even bother reading some of this stuff either. So whoever gave him the deed, gave him the wrong deed for when she bought it. Be that as it may, she or they bought it. So the attorney doesn't know what's going on there. And then they talk about cleaning up the title. So Todd says that she said, he says she said, it's really David that came in. Lori was out of the room, she's recused, had nothing to do with the hearing or any deliberations or anything whatsoever. Chinese wall, she saw nothing, heard nothing, till it's done and over and filed. But everything they have in their head, they got this obsession with Lori. So Todd Helms, she stated that they bought it from a foreclosure from the town, or they bought it from the town, and there was a title discrepancy or issue, which in her words, that made it unsellable or not worth anything. And I believe, going through the process that has the title cleaned up, and the quick claim deed was to take care of it. Cupola, do you know how the quick claim deed to resolve whatever the potential title issue there may have been? I'm not exactly sure what the issue is. I'm pretty sure just an ownership issue. I didn't research it. Just an ownership? They didn't own it. So if you don't own it, why would you pay taxes on it? And then they go down a little further. Matt, did we already ask the town manager to find the zoning records on this? Oh, yes, we did. Yeah, okay, she hasn't done it yet. Well, I haven't resaved anything yet. So again, it's all this collaboration with the town manager, tax assessor, town attorney, even the town clerk, because I find it hard to believe the town clerk does not know that there's electronic transmission available on this. But the way she couches it in terms of making it hard for anybody to go, I believe she's under orders, and I understand that, but a lot of people are under orders, and they should do what they're sworn to do, which is their duty. So I'm not thrilled about how she handled that. Anyway, so now we go on with the next, this is coming up to the last page there. Final thing on Longy. They're now talking about a newspaper article that Santinella provided, and also that Talbert provided, and they're all talking about, I think she's selling it for zero, haha, big joke. But even Cupola gets in on it. So he's talking to Todd, and the article makes reference to a potential sale of that property by Longy's to a builder. Are you aware of the potential sale? Todd, I am not. Cupola, if there's a sale of that property, you think it's going to be zero? I find that repulsive. Finally, page 88, and I hope Scott Delorge hung around for this. There's an email, and this one is from Helms, dated January 23rd, 2023, to Mario Cupola, and he's talking about his 490 spreadsheet. And then he starts talking about 336 George Washington Road, and he's using this as an example, and he's already discussed it with Cupola. This property was visited by my predecessor when the original application was submitted. On her visit, she was shown a bunch of Christmas tree saplings in the garage, and there was also an area in the rear of the property that was partially cleared. The owner stated that he intended to grow trees to a sellable height. The owner also is a landscaper by trade. She granted the application at that time. Upon my visit in 2021, now I happen to know, because I did the hearing on this also, that his visit was in a posted area, he didn't announce, didn't have any permission, and was caught in the garage, I believe, by the owner, who then, asked him about what he's doing there, and they had some words. But anyway, he says, upon my visit in 2021, I checked the rear area, and there were no trees growing. I had a chance to talk to the owner on his property. He informed me he tried to grow the trees, but the soil was too wet. I informed him that he would be losing 490 classification, which he understood. We had a very amicable discussion while on his property, and I left over an hour later. That didn't comport with the information that we got at our hearings. But then here's how it ends up, because we do know that he did some retribution against against Scott, because what he did is that Scott came before the council during public participation, made some comments that Todd didn't like. Todd was sitting in the back taking names, I believe is what he was doing at the time. And so after that hearing, he went and changed the pool size, increased it, added that it was heated, and it's not, and he then changed the garage to a pool house or a cabana. He then removed the 490 exemption. So during this council meeting, Nelson asked Capola about it. Capola said, well, I'll investigate for free and I'll get back to you. And I understand that Capola did get back to Nelson, but I don't know, I'm not privy to that conversation. But I do know I had a conversation with Attorney Capola maybe a month ago, going through some of these, because I told him, we have a difference of opinion on many of these issues. I'll give you the chance you didn't give us, and also I'll go through some of these with you and see what you think, and maybe you can change my mind and so on. So we started going through some of it, and he brought up the DeLorge property, and he confirmed that the guy changed the pool size after Scott had spoken at a public hearing. He added the heating pool, and he changed the garage to a pool house or whatever, but he thought that he was okay to remove 490. We still disagree on that because we know more about 490 than he does. But be that as it may, he did not issue a written report yet. He said, do you think I need to? I said, well, you did a report on the other stuff. Why would you not do it on this? And he was concerned because it might make the town look bad. So that's your independent counsel. So now I got to read the last, and this is the very last thing for the night, but it's going to leave you with this. This is again to Todd Helm's memo. Remember, he's talking about DeLorge, 336 George Washington Road. And here's the last couple of sentences. I did remove the 490 designation, but he's one of the ones the BAA gave back. The owner also attended council meetings, and it was apparent that he had had discussions with the BAA chairman as I watched them from the public seating area and heard the chairman thank him for coming. That's it. I mean, so now, DeLorge exercises his First Amendment constitutional right to speak, and now he gets this whacked at him that he would never know about were it not for Rachel Baird, Lori, Donna, and our persistence to try to get some of this stuff and unearth it. And you know who else wouldn't know about it? You wouldn't know about it. But you do now. And Scott DeLorge, that's page 88. So we will, it's getting late, but yeah. If anybody has questions, we'll stay here if they're, okay? So we'll go, okay, go ahead.
I don't have a question.
Yeah. This is Doug Finger.
Yep.
Incidentally, Doug has been one of our most ardent supporters when he was a Democrat, and he was so upset. No, he was so upset though that they would not let us speak, and so disgusted with the way they were doing this. So I don't want to say any more about. But he switched parties, went from majority to a minority. So he's a taxpayer guy. Thank you, Todd.
You're
Yeah.
welcome.
Thank you.
So, everybody knows you just said my name and what happened. So my thing is this, why are we here? Why are we here? These are our neighbors. These are our friends. These are people who have a lifelong residency and businesses in our town compared to people who don't even live here. Who are judging these three people because what? They don't like our town, they're getting paid by our tax dollars. And I'm gonna tell you something, I'm fed up with it. I'm fed up with it. Our farmers, no farm, no food people, remember that. All right? And I just, you know, I just,
Broke the
I broke it because it doesn't want me to speak. All right, who's doing this to me? Ellen? I mean, somebody else?
It's really a remote control mic, you know.
Well, I don't need a mic. Listen, this is wrong. This is
You
wrong.
hear my questions.
And I don't have my glasses, buddy, I'm sorry.
Here.
I'll do it. Yeah.
And you know something? This is totally wrong. And they will always, always,
We'll do the questions. Yeah,
okay.
Thank you.
I will always, always have their backs.
Good.
Always. Councilor Nelson and anybody else is here, all right? Lori Ungwire, and I see Kelly here she's running for this too. Obviously, yeah, of course, Marie, I'll never forget about you. You know, we're here because of them.
Vote for Capola. Thank you.
We're here because of
I did
them.
not vote for him,
Right.
period.
We did not vote for him. There was a certain situation, I'm not gonna bring it up that it happened. In my opinion, it was a set,
Yeah, thank-
preset
Yeah, we saw it.
thing to go against them. And I'm gonna tell you something, in all honesty, if anything happens to these people, I think all of us should come here and demand nothing happen to these people.
Absolutely.
Ever, ever, ever. They do their job, don't even get freaking paid for it.
Thank you,
I'm
John.
sorry, I'm sorry. I'm getting upset because I should be home sleeping in bed right now, I'm sorry.
So my questions were for you, but maybe Tom can read them.
I got it.
Yeah.
No, I got it. Oh, it's
I
for
want him
him?
to answer the question though.
Okay. Why is, well, yeah, go ahead.
I can't
Well,
see
no,
that, I'm
he
sorry.
can't see it.
Why is Helms still employed by the town of Enfield? You know what? Yeah, okay, but why is Helms still employed by the town of Enfield?
Oh.
We
I'm
didn't
gonna
do
give you,
anything.
I'm gonna give you reasons, all right? And everybody knows, I've been a union guy all my whole life, all right? There, he does belong to a union, he's supposed to be protected by a union. Is it wrong that he's still employed? Yes. Because if anybody in my union did what they did to you, they'd be birds and be gone. I would be gone. And we don't have that. We don't have that power as a council to make that. It's up to her. So I'm gonna say this, and I'm sorry if this, and again, Nick, and I know Nick is pretty much neutral about being a Democrat, but I'm gonna tell you this right now. We need to be put in charge this coming election. We need to be put in charge, because if that happens, nothing's gonna change in this town. Your taxes are gonna go higher and everything else. And I'm sorry, I'm campaigning. I apologize. Go ahead.
He did ask two more questions, but why is the town manager still here? Why is the town attorney still here, I think?
We don't
Yeah,
have.
You can't do that one. We gotta leave that
Yeah, I
out.
know.
This is employee
Yeah.
relations,
Right.
executive session.
Yeah.
You cannot be discussing this in public.
Okay, thank you.
Okay, that is that one. I do want to comment though too, we got a couple more questions. Are there any questions for this Doug or Rachel? Are there any questions for them? No, okay.
You don't have any questions for yourself?
Okay, yes.
I'm curious to know from the two attorneys, thank you very much for coming, it's been fascinating, thank you for what you did. How does this compare in your past experience? I mean, to me, I'm shocked. I didn't know it could be this convoluted, this crazy. I mean, is this common or are we an exception?
This has never happened before, to our experience with the Board of Assessment Appeals, to be put under such stress and pressure. And it started about a year and a half ago, one of our first meetings where we reported in our minutes, and the town manager didn't like them, and so she told us basically sanitize our minutes. We were offended by that because it's our minutes. And what she wanted taken out was a reference that we had that we had asked Todd if he was a certified licensed appraiser any place. His answer was no. We put that in the minutes. And they didn't want that in the minutes because they were afraid, well, for whatever reason they were afraid.
Can
But
I do
anyway,
this?
yeah, go ahead.
Okay. So this question was, when an assessor informs the taxpayer that the town does not have unsuppressed street cards, what options are available to the taxpayer to access this information? Well, actually, the last thing on our agenda tonight was motions and discussions. I was going to make a motion that we do a resolution that the BAA does not approve suppression of any field on public cards. And just so that you're aware, on the Connecticut Association of Assessors, ER1 says it's unethical for members to refuse by intent or omission to make available all public records in their custody for public review unless access to such records is specifically limited or prohibited by law, or the information has been obtained on a confidential basis and the law permits such information to be treated as confidential. So that is something that we just discovered in the Code of Ethics. They should not be suppressing the documents. It should be public information. So that is our last thing that we were going to do tonight, was make a motion and discuss that.
Is that your motion?
Yes,
Okay. Donna, you want to second the motion?
Second.
Okay, so now we can have a discussion. And my only thought with this is that he doesn't work for us, so we can't, it's not binding on him, but I think it's probably okay for us to do for a statement of our policy in terms of we would like to have no suppression of any of these figures or anything that comes up. They get a program paid for by the taxpayer. They get the information paid for by the taxpayer. It's inconceivable to me that it should be suppressed from the taxpayer. And then let the taxpayers decide whether they can read a card or they can't, or they care about their taxes or they don't. But they should have all the information available to them. It's kind of like when you go into a hospital for an operation and the doctor explains stuff to you. You need to make an informed, intelligent decision. You can't do that until you have all the information in front of you. And we're fortunate to have access to all this as long as it's provided. But this fake transparency that's going on here is ridiculous. Everybody in here should have access to all these records that are at the town clerk's office. They're electronically available. It's the only ones they want you to see are the ones that they said, here, go look here, but don't look over there. You should be able to look any place and then make up your own mind. You're big people, and Enfield is not dumb. So
No.
I do. So I'm with it for that.
okay.
Yeah, I'm on board.
Okay. All in favor?
Should not suppress.
Aye. Okay, so we just passed it. So we're gonna, we
But they
will
should
make
talk
our.
to the council because.
Oh, yeah, you guys gotta, spread the word about what you heard here and tonight and so on. And I do wanna say, one other thing too, is that for the people that have been supporting us, one who has paid a price is Nick Hopkins. Because Nick Hopkins was initially a liaison to this. And Mike Ludwig also liaison. Mike couldn't be here, it's an employment issue he's gotta handle. But Mike has been supportive also, but with regard to Nick was a liaison, and a liaison is supposed to get information to the investigator and respond back and so on. Well, he was doing his job so well that they had to manufacture some grief against him to get him removed from that. In return, what they did is they took him off a whole bunch of panels and stuff he's on, and now, because he still is a firm supporter of our right to speak and the taxpayers' right to know what's going on, that he's being punished with a primary over in his district in 4. So we have one Democrat who is supporting us solidly and supporting the taxpayers so far. So we'll see about the rest. But the other problem with the liaison is they replaced him with Santinella. So when Santinella's not riding around checking your driveways for cars out-of-state plates, he's supposed to get people to go and see Mario. At least that's what Mario said. Mario was asked, how come you didn't talk to any farmers other than Art? And he said, well, it's up to the liaison. Santinella didn't give anybody to talk to, not a soul. Did he not know anybody? But I know that he's been appointed an ambassador, basically, by Ellen for the Todd Feinberg show, so that Ellen sent an email to Todd Feinberg that he's made public that said that it cost the town $100,000 for this investigation. And she didn't want to go on the air, but she wanted to send Santinella because he could explain things so that Santinella was going to represent the administration against the BAA and taxpayers. Just so you might want to remember that in District 2 if you're from there. So, how many years did Ms. Longi pay taxes on a property she didn't own? 5 years, and that's because she didn't know she didn't own it. It came up when she was selling to somebody else who then had a surveyor that determined that she didn't own it. If the town wouldn't fix it, then who paid for that? Or does Ms. Longi get a tax refund? That's interesting because that's where Donna was from in terms of they think a zero value was bad. Donna wanted to give her back $2,500 for the taxes that she had paid for the preceding 5 years. We didn't go quite that far, but there is precedent for it in a case that I gave them where the town had done bad things to somebody and they had to pay back $99,000 worth of taxes that they overtaxed them for a few years. The reason I'm familiar with that case is that was my wife's. Because about 15 years ago, the town trespassed on her property, diverted water, and ruined a subdivision, and then denied it, even though they had had a town backhoe and bulldozer and town employees that did it. Went to court. We ended up, once we were able to prove it, the town stipulated and was told to pay, reimburse the taxes, and they reimbursed. So Lori probably could have got it if she wants to sue, but is it worth $2,500? Probably not. But be that as it may, that's, are there any other questions anybody has?
Tom, I got a question for
Yeah.
Attorney Trubisky. What gives the assessor the right to, when you go to do the appeal with the BAA, when they don't return it back, and he just goes back and does it all over again? What gives him that right to overrule the BAA? Got figured that out there with the judge once it gets to them.
Well, I don't know the exact facts. I don't know the exact facts of this situation, but I don't believe an assessor has the power to overrule the Board of Assessment Appeals.
He's done that twice to myself, and I'm sure to some others in this room.
I'd be interested to see the statute that gives him that authority. I have not seen it.
Doug, it's the one he changed, the one you guys changed that he ignored. That was the one. But you definitely want to talk to him after the, yeah.
Yeah, I think that statute, even in its current in its current form, does not authorize an assessor to override a Board of Assessment Appeals. The only one that has that authority is the court.
Okay, is there any other questions?
Your mic's not working, so I couldn't
Okay,
really hear.
we're going to adjourn, but if anybody wants to stay and talk, we're welcome. So,
I'll make a motion to adjourn.
Second, all in favor? Great, we're done. Thank you. Thank you, you. Thank you
so
guys.
much.
Yes, appreciate it.
Great microphone that we have here.
Did you walk? I know. I think
I have a quick question. I didn't know if I heard you right. Help me if I have your numbers right. So is that 12,117 and 12,900? A and 12,119. So one of them was 12,17 and the number was A.
Doug, nice to see you again.
That one was on value, correct? And then the other one was on the actual changing into a different type, correct? And the 19 had a longer statute of limitations, so, and the other one had 9. Yeah, can you actually get, could somebody get hit with both because it said you over, so what one takes precedence? Okay. So you could be assessed for something else.
Well, you know what? Why don't you ride with that time frame, right?
Yeah, because when I was hearing you, I'm like, yeah, and it was so long ago, I'm like, I hope I have my numbers right. This guy comes out there. Okay, thank you, appreciate it. Hi Carol, how are you?
Good, how are you?
Good, thank you.
Go to your
Great
house
job,
first,
thank you.
And then go get my car and come home with me. Okay?
I'm not leaving.
It was a lot of work, but we've been in attack for so long. That it was a well-oiled machine.
And you know, she's the representative, Carol Hall, who sponsored that bill. That yeah.
We put it in filing the documents for us to have to go through it. On top of our.
No, I know, exactly, 2 lives.
Yeah, I'm worried.